Docket. The state of Florida versus Brian McKenzie. Counsel?
Good morning. It's very nice to be with you this morning. My name is Jeffrey D'Souza for the state of Florida. Mr. Chief Justice, and may it please the court, the Florida Sexual Predators Act was designed to protect the community from a group of offenders that the legislature deemed to present a, quote, extreme threats to the public safety. And as a result, the act requires that every sexual predator be designated and subject to a variety of safeguards. Now, Mr. McKenzie doesn't dispute that his sexual offense qualified him under the terms of the act, and he also doesn't dispute that the circuit court therefore had a statutory obligation to designate him, which it initially failed to do. His claim is instead that the very moment that he completed his sentence, he was now and forevermore free from the circuit court's jurisdiction.
Was this a negotiated plea?
Yes, it was.
So my understanding is that he entered a nolo plea to, what was it, 3 years probation or something? Well, being classified as a sexual offender places upon him tremendous numbers of limitations as to where he can live, where he can attend, where he can walk, can go near school, can go near a church, that kind of thing. So it's a major imposition, so to speak. Isn't that something that he should have known about when he entered this negotiated plea? That he was going to be classified? Because he was basically, imposed on him way after he finished his sentence. Should that not have been an element or a position of a negotiated plea?
So Justice Labarga, what the courts have routinely said is that the imposition of either the sexual offender or sexual predator designation is a collateral consequence of the sort that does not need to be disclosed at the time of the plea. Now, I understand your concerns. I think I can assuage some of them by pointing out that he did understand at the time he entered his plea that he would be subject to registration as a sexual offender. And I believe that all of the restrictions that you refer to also apply to him under the terms of the sexual offender statute. Now, what the Sexual Predator Act does is it imposes additional restraints, most notably the requirement that law enforcement engage in community and public notification. But I think that, to the extent he's arguing a laches defense, I'm happy to talk about that first. We think that there are a number of reasons why that argument fails. The first is that laches is an equitable doctrine. And as the Third District recently pointed out in Hernandez's decision, we don't believe that a defendant can invoke laches to overcome the clear expressed legislative will, for instance, in the Sexual Predators Act, where in subsection 3, the legislature laid out its purpose and findings and made entirely clear that, quote, it is necessary in order to protect the public that each sexual predator be designated. So that's the first point. Laches as an equitable doctrine can't be used to suborn the legislative will and policy determinations. Our second point about laches is that he hasn't established any form of prejudice. The two types of prejudice that he espoused are, number one, and he says this in his brief, he has to be hauled back into court years later, which I think is always true in laches cases, and courts haven't recognized that as a type of prejudice. And then number two, he says that after 7 years, my defense attorney destroyed the defense file, and as a result, that's impaired my ability to defend myself. In point of fact, though, there really is nothing to defend here, and he's already conceded all the elements required for the imposition of the designation. As soon as
I'm sorry to interrupt you. Can we go back to the statutory and jurisdictional issues that seem to be at the heart of the case? So it seems like 4C really supports your position, but you guys mentioned it in a footnote and didn't really elaborate on it. And, it talks about if someone is, designated by FDLE or DOC as a sexual predator without the court having made a finding, the state attorney has to bring it to the attention of the court, and there's no time limitations or anything like that. Is there a reason why you didn't? I mean, first of all, so does this help you? And if it does, I'm just curious why it wasn't something that you relied on more.
So If Your Honor is referring to subsection 5C.
No, I'm talking about 4C.
Okay, so the reason that we're not relying on 4C is because the plain language of that provision seems to require that the offender have been designated
by DOC or the department. But I guess my point is, if the heart of the argument on the other side is that, you know, once probation ends, you know, you're done. There's nothing, you know, the court lacks quote unquote jurisdiction to fix its mistake. 4C seems to cut against that because it doesn't talk about when the improper designation occurs or anything like that. It's just kind of an unlimited freestanding, you know, it seems like in this case, if FDLE tomorrow put this person on its registry, you could just point to this statute and say, okay, fine, now the state attorney gets to go in and fix it. I mean,
yeah, that's correct. So there's a lot to say about that. The first point is that the reason we haven't relied on 4C is because, as I pointed out, it requires that law enforcement have designated that person. But 5C, the last sentence, says that law enforcement cannot do that without an order from the court. So I don't know that that's a...
4C, I mean, it says, it seems like the legislature anticipated that there would be mistakes. And it says, you know, if the court didn't for whatever reason, it seems like it very much supports the idea that the legislature views this as a lifelong kind of status that carries these consequences. And the legislature wasn't worried about whether you're on probation or the timing. They want this designation to be made, and they want the public to be protected through the means that the statute is put into place.
So at bottom, we agree. The reason we haven't gone with 4C is because of that textual problem, but I think that 4C and 5C share a couple of things in common. They're really important here, and you've alluded to them, which is that the fact that 4C and 5C are not time limited in any way indicates that there is ongoing sort of procedural jurisdiction so that the trial judge can correct its omission at any time. If the legislature wanted to time limit either 4C or 5C, it could have done so in any number of ways. And a good example of that would actually be a neighboring statute, 775.24 sub 3, says that there are certain types of orders that an affected law enforcement agency can move to correct, quote, within 1 year. So there's an example of where the legislature affirmatively placed limitations on the court's continuing jurisdiction. Now, it hasn't done that with respect to 4C and 5C. I'd make sort of like two broad points about why we think, and that certainly goes to it, but why we think that there are either of two reasons why the court has continuing jurisdiction up until the point when it satisfies the ministerial act of designating a sexual predator. The first point is that we believe that the act itself, within the confines of a criminal case, because it makes the imposition mandatory and specifies that under no set of circumstances can the courts eliminate the need to be designated, we think that that creates an ongoing jurisdiction. The second point is that the way that we read 5C is that it really is a procedure and a command to law enforcement. But to the extent you disagree with our other argument, we think that it could also be read to create an independent basis for jurisdiction, sort of in the way that Justice Muniz was referring to. But going to the first point, I want to first address Mr. McKenzie's argument in the brief that there is a line of cases from this court, including Francois, as well as a series of district court decisions, which he reads for the proposition that as soon as he completes his sentence, he is entirely free from the court's jurisdiction for this purpose or for any other purpose. And we believe that he's reading those cases too broadly. What they actually stand for is the narrow proposition that when you've completed your sentence, the judge loses the authority to reopen the sentence later by increasing it. And that certainly makes sense. For instance, the probation statute says that a judge retains jurisdiction over allegations of a violation up until the point when the probationary term ends, after which point it loses jurisdiction. So those cases make sense in that light. But what they do not say is that a court loses its general criminal jurisdiction for all purposes as soon as the sentence is completed. And to give you an example of an instance where I don't think it would be disputed that a judge would retain jurisdiction for some limited purpose, a defendant many years after the fact can move to seal and expunge his criminal history record under 943.059. So that's an instance where the sentence has completed, but the judge nevertheless has authority. So turning to the Sexual Predators Act in our first argument, we think that there are really 4 reasons that you know that the Act creates a continuing jurisdiction. The first reason is that the imposition of the designation is mandatory, and it's made mandatory in a couple of different places. An example would be subsection 4A, which uses the language, an offender, quote, shall be designated, shall be designated. The same thing is true in 5A2, where mandatory language is used. The sentencing judge, quote, must make a written finding, must make a written finding. So it's mandatory and it cannot be avoided in any way. The second argument is that neighboring statute I referred to a few moments ago, 775.24 sub 2A, it goes a step farther. Not only is the imposition of the designation mandatory, there the legislature made clear that for no purpose, not even for the purpose of accepting a plea agreement, can a judge enter an order that would purport to exempt an offender from being designated. And so I think that what you infer from that is not only is this mandatory, but if the legislature didn't want a judge to be able to expressly say, I'm going to exempt you, it couldn't do the same, and we're not suggesting that's what happened here, but it could not do the same via the back door by simply declining to enter the designation. So that's number 2. Number 3 is the fact of 4C and 5C. Even to the extent that those do not independently create a basis for jurisdiction, they clearly, at the very least, acknowledge that a court has continuing jurisdiction to enter the designation at any time. That's the entire point of 4C and 5C. And the last point is that nowhere within the text of the Act, unlike elsewhere, did the legislature place any kind of affirmative timing limitation on when a judge can correct the omission. So that's our first argument. The second argument, to the extent you're not willing to quite go that far and you think that we need sort of an affirmative grant of jurisdiction, you could very easily read subsection 5C, the so-called recapture provision, as doing that. And I think that Mr. McKenzie's argument here is not to say that 5C doesn't either acknowledge or create jurisdiction. His point is that Mr. McKenzie himself didn't fall within the plain text of sub 5C, and that's not correct. And I'll tell you how we read subsection 5C and why he in fact does fall within its text. So if you have it in front of you, I'll be talking about the first sentence of 5C, and I want to break it up into a first clause and then the second 2 clauses. And my point is that the first clause tells you who it applies to, who 5C applies to, meaning which set of offenders. And it uses very broad language in that respect. It says, quote, an offender, ... as required in paragraph A. An offender, meaning any offender, as required in paragraph A. That's who it applies to. And Mr. McKenzie is unquestionably an offender in paragraph A. Paragraph A sets out A1, who are Jimmy Rice offenders who have been civilly committed. Subparagraph A2 would be those like McKenzie who have a qualifying offense. And then A3 would be individuals who move to the state of Florida but have an out-of-state qualifying offense or an out-of-state civil commitment. So by referring to an offender in paragraph A, 5C is telling you quite broadly it applies to every single category of offender covered by the Act. Now, his argument is about the second 2 clauses, clauses 2 and 3. Our response to that is what those clauses do is simply clarify for law enforcement which state attorney they should contact in cases where it would not otherwise be clear. So the first clause deals with which offender, and the second clause deals with which state attorney. And the reason that the legislature would have specified in the second 2 clauses, A1 and A3, is because as to those individuals, it may well not be clear which state attorney to contact. And the clearest example of that, I think, is subparagraph A3. Those are offenders who move to the state but have an out-of-state either qualifying offense or were civilly committed out of state.
So you've got to, I mean, I'm sorry to interrupt you. You've got a great argument as to the first clause, but I mean, you admit that it's a little bit of an awkwardly worded sentence in the sense that the first clause is broader than clauses 2 and 3. I mean, I don't think it defeats your bottom line argument, and I think the next sentence is obviously supports your overall position, but it is kind of an awkward sentence.
I agree, and I'm not here to tell you that this is the clearest legislative drafting that I've ever seen, but I think the point is that the best and most natural reading of the way that first sentence works is that you have this very broad first clause that applies to all offenders, and the second clause is more circumscribed, but there's an explanation for that. And that's because with respect to A1 and A3 offenders, it might not otherwise have been clear to law enforcement which state attorney to contact. So take, for example, a person who moves from Georgia and had a qualifying offense in Georgia, and so they qualify in our state. Maybe they live for 6 months in Miami, and then 6 months later they move to Orange County. In that instance, it might not be clear to law enforcement, do I contact the Miami state attorney where the offender first lived, or do I contact the Orange County state attorney where they currently live? And so the second clauses just clear that up. And I think that's the proper way to read them. And the reading that Mr. McKenzie is urging on you would require, I think, quite a leap, because what he's telling you is that the reason that his category is not included there is because the legislature affirmatively wanted to exclude him from recapture, which I think is highly unlikely, because Mr. McKenzie's category of offenders is every bit as dangerous as every other sexual predator listed in the Act. And so there's no reason to believe that the legislature intended to exclude him, rather than simply because it didn't think that it needed to.
Why do you think it's any less clear as to where you'd go to it for an A1 offender as an A2 offender? I mean, they both had courts that that had the judgment that qualified them for the status. And the legislature could have said, with respect to either, go to where they are now, go to where they reside. So why? I mean, I'm not understanding your logical distinction between those two.
So that was a question in my mind, Your Honor, as well, until one of the attorneys in our office pointed out to me that in the context of Jimmy Rice proceedings, you can be civilly committed even if you are in custody for a non-sex related offense. So you may have in Miami been prosecuted and convicted for a sexually violent offense that would qualify you for civil commitment, but you're not civilly committed. You then move to Orange County and you commit a white-collar grand theft, and you are now in custody. The state can attempt to civilly commit you under the Jimmy Rice Act at that point. The reason that the second clause lists A1 offenders is because it might not otherwise be clear to law enforcement. Do we reach out to the Miami state attorney who prosecuted the sex offense, or do we reach out to Orange County, which prosecuted the current offense? And so when that clause talks about the A1 offenders, I think it's probably saying the offense, meaning the offense for which the offender is currently in custody. So it does clear up confusion there. But either way, even if you believe that this is ambiguous, or there is some sort of, in your mind, irreconcilable tension between the first clause and the second two, we believe that at best, or maybe at worst, the provision is ambiguous. And
Counsel, you're now well into your rebuttal time. You've got about a minute and a half left. You can keep going, but you're going to.
I'll just take up these 15 seconds to finish the point, which is that if you believe that 5C is ambiguous, we think it's entirely appropriate to look at subsection 3, which lays out the legislature's purpose and findings, and those make clear that under no set of circumstances would it have intended for anyone, including Mr. McKenzie, to slip through the cracks here. So thank you.
And I will give you an extra minute on rebuttal. So you'll have 2 minutes on rebuttal.
Thank you very much.
All right. Thank you. Counsel? You need to unmute.
I apologize. Can you hear me now? Okay. Good morning. May it please the court. I'm Terrence Kehoe, appearing on behalf of the respondent in this case, Brian McKenzie. We submit that Mr. McKenzie's criminal case was over when his sentence ended in April of 2015. and that the circuit court lacked jurisdiction over both him and his case in 2018 when the state sought to impose the sexual predator designation. The Fifth DCA essentially said two things. Number one, that the circuit court lacked jurisdiction or lost jurisdiction over the criminal case in 2015. Now, there's been a little bit of discussion about jurisdiction in this matter. The state really in its briefs doesn't address the Francois cases. My opponent did in his presentation, but the bottom line is there's no case that I could find and that the state's ever presented to the court that says that if you finished your sentence, your criminal case continues for some other sexual predator purpose. They're trying to create a sexual predator exception to jurisdiction, and it doesn't currently exist in the law in the state of Florida. Second thing, every one of those cases, and the other thing about jurisdiction in this matter, of course, you have Judge Shepard's dissent in Cuevas, but you also have the second DCA in Almond, where the three judges joined an opinion that said they don't believe that Cuevas, the court had subject matter jurisdiction to do what it did. So you have essentially 7 DCA level just judges that would not have supported the state's argument in this case.
Counsel, I'm sorry to interrupt you. I mean, I understand in the normal case that, you know, there's a certain punishment that's imposed. There are limitations periods in statutes that are imposed. I mean, in this case, though, you have essentially an ongoing permanent set of consequences that flow from this automatic, once the predicate facts are established, you have this kind of automatic designation as a sexual predator. And you see that the legislature wants it to apply even to people who weren't convicted of their underlying offense in the state of Florida. So it's not really necessarily linked to the particular criminal case. And so I understand the textual stuff about, you know, if you want to read this recapture thing as somehow creating this carve out for people that you essentially can't fix the error for them. But to the extent that you're arguing that it's a quote unquote jurisdictional issue, it doesn't seem like the whole statutory scheme would support that.
Well, I'm going to get to 775.21. Justice Muniz, I think that the key is that the statute doesn't say explicitly what the state wants you all to decide. They want you to infer from take this section and this section and come up with a conclusion that obviously the circuit court had jurisdiction to do what it did. But you have to take these sections individually. There's no question that he would qualify as a sexual predator. The state acknowledged that he's registered as a sex offender since 2009 and complied fully and all that kind of stuff. All right. So he's already in the system. He's not like these guys from Indiana who comes to Florida and may not be in the system. He's not like a civil commitment guy who's not already in the system. He's in the system. Okay. But there's no question that there's multiple statutes that say this is important. We want sexual predators to be identified in the community and such, and we want them registered, and we want them penalized if they don't do what we say they should do.
Mr. Kehoe, and I apologize for interrupting, but is your position that the jurisdictional argument is the natural consequence of that the legislature could not have said in 775.21 that you could go back to the judge that had the original case in order to add the designation if it wasn't done originally? Are you saying that the statute could not have done that? No, I'm saying the statute doesn't do that. Okay. And then how would you deal with 4C?
4C,
if the court, for whatever reason, did not make a finding at the time of sentencing, that you go back to the sentencing court. The state attorney should now bring the matter to the court's attention.
4C, I apologize. I think the state correctly conceded that 4C doesn't apply. If you look at the first 10 words or so of 4C, it says, if an offender has been registered as a sexual predator by the department. of Corrections or FDLA or something like. That's the condition precedent of everything else in 4C. And as they concede, he never was registered as a sexual predator. So if he wasn't registered as a sexual predator, 4C cannot apply on its face. And they never really.
Why wouldn't it be reasonable to read these together and say that, well, there was no need for the statute in 5 to tell the parties where to go, tell the law enforcement agency or department where to go, because we already told them where to go if the trial judge, for whatever reason, didn't make the written finding in 4C. I mean, if you sort of read those together, 4C at least says where to go with respect to the.
Well, let me say this. The statute, the part that should have applied to Mr. McKenzie is the part that says it should be applied at sentencing, right? We all agree on that. And that's why if you see in this order, although it's a fiction, it says the circuit court's order in 2018 says he's imposing this at sentencing, which we know is not accurate. So that's how he tried to tie it in, dovetail it into the statute. The bottom line is that this statute is not self-executing. He may qualify under this statute as a sexual predator, but if the judge doesn't do it at sentencing, judge doesn't enter the written order at sentencing, he's not a sexual predator. If he doesn't enter it.
Counsel, let me ask you this. Would you concede that this act of the judge is a ministerial act given the whole context here?
No, not at all.
Well, why is it not ministerial? But because the judge has no discretion in doing it. I mean, it seems to me that that's the classic ministerial act when a decision maker is required to take an act without having any discretion whether to do it or not. The only reason that this judge could fail to make that determination was through an error. Isn't that correct?
In this particular case, but the statute recognizes, because in several places it says, essentially, if the court doesn't make the finding, you can't put him on the registry as a sexual predator. So they recognize that a court may not do it. And of course, you have recapture provisions and different things like that in that situation. It's not, I don't care if it's ministerial or not. If you don't have jurisdiction, you can't do it. Jurisdiction is fundamental, all right? You can't do anything ministerial or otherwise if the court doesn't have jurisdiction over the defendant or the case itself. But I want to talk about 5C.
Why isn't it, if I look at the whole statute though, it seems like the fair reading of the statute is that the legislature cares about two things. One is they unequivocally want people who qualify for this designation to be so designated regardless of when it happens, in the sense that if there are mistakes made, whether it's the judge doesn't do it at sentencing or an agency wrongly puts someone on a list before the, before the written finding. So that's kind of the first thing that the legislature cares about. And the second thing they care about is due process, because they make it clear that although it is a ministerial act, it does have to be, there are some predicate facts that need to be established first. And so, the remedy in 4C is take the person off the list, give them a hearing, and if they qualify, then they go on the list. So why aren't those two things the most critical things that the legislature is getting at here as far as what the statutory requirements are?
Because you can't just take the whole thing and say the purpose of this is that he should be placed on this, and therefore we're going to find a way to place him on this list. Okay, has to be some explicit authority in this designation section that says this is how we can do it. All right. Part 3, which has all these things about the legislative intent, doesn't say how this guy's going to be put on the registry. Part 4 doesn't answer the question. 4C just doesn't, for the reasons we both have mentioned earlier. So 5C.
I'm sorry to interrupt you. Hold on. Wasn't it your position though that so the statute explicitly says that the designation has to be for an A2 person, it has to be made at sentencing, right?
It does, but
Okay,
then,
but your position is that as long as the person post-sentencing, as long as they're still incarcerated or on probation, it can be fixed at that point.
well, that's not my position, but that
It's
is the
not?
case law from 3 DCAs right now, which I don't need to argue with for the purposes of this appeal, okay? The 2nd, the 3rd, and the 5th, of course, in my case, have all said that. So I'm not going to
So-
dispute that right now
No,
because
but-
I don't need to.
I'm sorry to interrupt you, but I want to understand though your jurisdictional point though. I mean, is your point, I mean, it sounds like what you're just now arguing is that if you're not, you know, the statute is very specific about how and when it tells the court to make the designation. And if they don't do it that way, the way it's explicitly laid out in the statute, then you're done. I mean, why is it?
Well,
if you're saying the recapture thing doesn't apply to someone in your client's
yes,
situation.
I'm going to get to 5C. I'd love to in just 1 second. I do want to say something. The Fifth DCA said cases have to end, okay? The expectation of everybody in this case, when the DOC said he's finished and the sentence is over with in April 15th, is that this case ends. His sexual offender registration didn't end, and he knows that. He's continued to comply. But the jurisdiction of the circuit court over Mr. McKenzie ended in April of 2015, okay? And there was nothing else to bring him back within the jurisdiction of the circuit court. I do want now, if I can, to address 5C completely so that I can parse it sentence by sentence because my interpretation differs from the state. And this is the section that, frankly, everybody that's ruled against me. Well, the 3rd DCA, this is the section they relied on. All right. But 5C says if the department learns essentially that somebody hasn't met the criteria, then they shall notify the state attorney. All right. So that's if we learn that he hasn't been properly designated, we notify the state attorney. In 2 circumstances, A1 and A3, which we all have agreed don't apply to Mr. McKenzie. Judge Shepard said it doesn't say A2, and he points out that the legislature dropped A2 in the past. All I can tell you is that A2 isn't in it. The state wants you to read A2 in it. If you don't read A2 in it, you can't go with the state in this case. And my position is if you read the plain text of this statute, the first part of C, 5C, does not apply to this A2 sentence. The A2 provision in Mr. McKenzie's case. The second sentence of 5C says the state attorney shall bring the matter to the court's attention, et cetera, all right? What's that all about? It obviously means the matter that's referred to in the first sentence. So the second sentence doesn't grant any broader power or jurisdiction or whatever you want to call it to the state attorney. The first one says law enforcement or department, you notify the state. The second one says state, in this instance, for this matter, you notify the court. And then the third one, of course, says the court can either find yes or no, and et cetera, et cetera. So it's a logical progression, and it just doesn't include A2. Now, they want you to read it in their brief. They concede that 5C does not directly address jurisdiction, and that's their initial brief, page 9. So it doesn't directly address it. They want you essentially to read 3 and maybe 4 and read some of 5 and come up with this ruling. The Fifth DCA disagreed with that. And obviously 2-1 in the 3rd DCA agreed with them. And in Almond, the only other case really that talks about this, the 2nd DCA didn't have to reach that point because Mr. Almond was still under a state sentence.
It seems like to me that the point here is not that it specifically, whether it specifically addresses or does not address jurisdiction. It assumes jurisdiction. It doesn't talk about jurisdiction. Well, it assumes that the jurisdiction is there to deal with this matter.
No, I would disagree. It's very specific in what it says in 5A, B, C, and D. This is a very specific statute, all right? They're trying not to leave any gaps.
Can you address, so I understand that if we read the statute the way you're wanting us to read it, and the legislature did something that might not make sense, then maybe that's what the law is and there's nothing the court could or should do about it. But is there a way that, I mean, the counsel on the other side has given an explanation for why the legislature in 5C would have given specific directions in the A1 and A3 situation. Can you give us a reason that it would make sense for the legislature to say you can do a recapture in these other categories and you can fix mistakes in 4C, but we don't want to give courts the authority to fix mistakes in this situation?
Well, the courts have given have filled in that gap, and basically both the third in Cuevas and the second in Almond and now the fifth in McKenzie has said, as long as he's under state control, probation, prison, community control, you can bring him in. I think one of the cases is 14 years later after sentencing, as long as he's under that. But what McKenzie has said is that 77521, once a case is over, doesn't allow you to bring him in. And obviously that's the different point in McKenzie. Cuevas, of course, doesn't even discuss jurisdiction. They just say the statute allows it. They almost treat this as a self-executing statute without any limitation whatsoever.
But I mean, is your position though that the 5C, if you're right that 5C only addresses the A1 and the A3 offenders, is it your position that the legislature intentionally wanted to isolate those two situations? And if so, what would the reason for that be?
Well, number one, anything I say on this point is speculation. I assume that when they say A1 and A3, that's with their intent. And I assume that when they skip A2, it was their intent to skip A2. I mean, they write statutes every day. I don't know why. My thought is that their thinking is the same thing as the court in Cuevas and Almond. Most of these sentences don't end in 5 or 6 years like Mr. McKenzie's, all right? A lot of them, you're under sex probation for 15, 20 years, or you're in prison for, like Mr. Almond, for 12 or so years and probation after that. I just assume that they believe that this is going to be discovered and this is going to be brought to some court's attention. In Mr. McKenzie's case, in the record, you will see that a DOC employee wrote to the circuit judge in Orlando about 10 days before the probation was ending, and brought up the fact about counseling, and he was in compliance and all that kind of stuff. So they were just going to allow it to end. Why doesn't that DOC person's obviously reviewed the case, understand that this is a sexual predator and bring it to his attention? If they did in 2015, obviously we wouldn't be here today. This is one that fell through the cracks. This ruling will probably affect one person, but I absolutely believe that the Fifth DCA got it right, that this statute, and particularly 5C, does not grant jurisdiction because the criminal case was over with. And I would ask that you affirm the 5th District. Thank you for your time.
Thank you for your argument. Now for rebuttal.
Thank you. I'd like to start with a point of clarification about what our position is with respect to 4C and 5C. Because Chief Justice Kennedy, I think you sort of made the point that I was trying to make, which is that the existence of 4C and 5C, even to the extent that they do not independently create jurisdiction, they presuppose that there is continuing jurisdiction. And that jurisdiction is not time limited in any way. And so that we think that whether or not Mr. McKenzie falls in the plain language of 4C or 5C, we think that those are just procedures that assume the existence of jurisdiction, and that because the legislature has so clearly made the imposition of the designation mandatory, that the court could take that action at any time, and that it has continuing jurisdiction up until the point when that ministerial act is done. I want to make sure that I address any of your outstanding questions. If there aren't any, I would leave you with 2 quick points. The first is that if you were to accept Mr. McKenzie's position here, you would also be accepting the proposition that the legislature created a scheme in which you could imagine that there was a plea bargain, you'll plead guilty, you'll be convicted of the qualifying offense, and you'll serve a 1-day jail sentence, And maybe that offender has 1 day of jail credit. So they've effectively served the sentence. Under Mr. McKenzie's view, there is absolutely nothing that that trial judge can do now or ever to correct its mistake if at the time of sentencing it didn't pronounce the designation. And given the clear statutory purposes here, we don't think that that's plausible. The second point, and I'll leave you with this, is that Justice Muniz, you asked my friend on the other side, what was the legislative purpose in admitting the A2 offenders? And I'm not sure that there's a real explanation for that. It would have been inexplicable. And we think that we've given you a plausible reading for why they're included. And we're therefore asking that the court quash and remand. Thank you.
All right. We thank you both for your arguments.
Thank
And
you.
we will now prepare to proceed to our next case.